Hello, everyone. My name is Janna Wessels. I'm assistant professor at Vrije Universiteit Amsterdam, as well as research associate at Giessen-University for the PROTECT.project. And I am speaking on behalf of the Giessen-based team today, which consists of Jürgen Bast, whom you saw yesterday, Pauline Andres de Oliveira, and myself. And I'm pleased to share some of our preliminary findings with you today. Note that obviously this is work in progress, and it is part of the larger work package number 2 of the PROTECT project. As you may know, the overarching objective of work package 2 is an analysis of the impact of the global compacts on the right to international protection, including the interactions of the compacts with pre-existing legal frames of protection. So really the core of Work Package 2 is research into the legal relations between the compacts, migrant and refugee rights as they're laid down in international law, and the prospects also for common European asylum system reform. And within the project, we work with the following hypotheses. We think that the Global Compact for Migration is actually more relevant than the Refugee Compact for the international protection regime. And that is because both of its institutional features and its substance. Also, we think that the non-binding character of the Global Compact for Migration is not an obstacle to its potential impact, but rather a common feature of modern international law. And finally, we think that the GCM, even though it does not mention refugees, is also relevant for protection-seeking migrants. And what I'll do today is I'll illustrate this with an example from our ongoing research, namely the use of policies of planned destitution in the EU. So what do I mean by planned destitution? Planned destitution refers to situations where social and economic exclusion is used as a policy tool to control migration, especially as a deterrent against unwanted migration, including forced migration, so protection-seeking migrants. This definition is inspired by the work of Yves Lester from 2018. And so do we find policies of planned destitution in EU migration policy? Well, in our research, we have found such policies in at least 2 areas. One is policies that seek to prevent movements of asylum seekers within the EU, and the other concerns measures that intend to enforce returns of rejected asylum seekers, other irregular migrants, to third countries, so to their countries of origin or former residence. Both these policy areas involve, therefore, constellations where the migrant does not leave when the EU or the member state expect them to. Fabian Georgi has called this the obstinacy of migratory movements in his book from 2019. I'll explain both of these policy areas in some more detail. So for secondary movement. As you may know, the Dublin regulation assigns one particular member state that is responsible to process each particular asylum claim. However, some asylum seekers move on to other member states, and regardless, and those movements are called secondary movements. And the EU and all the member states want to prevent that. So what do they do? Well, member states sanction such secondary movements, for example, with curtailing material reception conditions, those that are usually granted to asylum seekers, such as housing, food, or clothing. The CJU, the Court of Justice of the European Union, has repeatedly held in judgments that such policies are illegal. For example, in the early judgment, Simard and Giessen-team, but also much more recently in the case of Hakbin. And the court thinks it's illegal because the EU legal framework does not foresee sanctions for onward movement, for secondary movements. And that emerges from the Reception Conditions Directive. In response to this situation, the reform proposals that have recently been tabled for the common European asylum system now plan to create a legal basis for this type of policy. So for this kind of policy of planned destitution. As regards the other area where we found policies of planned destitution, namely the question of deportations, the situation is as follows. Some rejected asylum seekers and also other irregular migrants who don't have a right to remain, who have been issued a return decision, cannot be immediately deported. And the reasons for this may be of very different kinds. So they may be humanitarian, they may be legal, or also practical in nature. For example, they can involve the non-refoulement principle, but also much more mundanely, delays in obtaining the necessary papers from third countries, or also the unwillingness of the respective person, the individual, to cooperate. But the EU and other member states want them to leave, of course. So how do they respond? Well, the EU legal framework does not say anything on this. So it does not define the status and the rights of non-removable migrants, those who cannot be deported. That emerges from the Return Directive. So this is a legal vacuum that is then filled by domestic law, by the member states. And many member states respond with creating hostile environment policies. This term was coined by Theresa May a few years ago in the UK. And these hostile environment policies often involve making access to basic needs conditional upon cooperation with return. We find that in the Netherlands, where it's been in place for a long time, also in Austria, and also since a recent legislative reform in Germany. Now, even though the problem is known, the reform proposals for the common European asylum system does simply not address this issue. So here in this situation, the EU tolerates or condones these policies of planned destitution. So then the question arises, what does the Global Compact for Migration have to say on this? Well, when we look at the text of the Global Compact for Migration, we find Objective 15, which states that all migrants, regardless of their migration status, should be able to exercise their human rights through safe access to basic services. What do we make of this? How does this relate to existing legal frames? And when we look at the text of Objective 15 more closely, we actually find that it enshrines a human rights-based socio-economic subsistence level. And this emerges or is laid down in various human rights instruments, such as the International Covenant on Economic, Social and Cultural Rights at CESCA. This is a binding human rights instrument, and the body that interprets its provisions, the Committee on Economic, Social and Cultural Rights, has clarified that a minimum core obligation exists for contracting states to ensure that at the very least a minimum essential level of each of the rights in the covenant is incumbent upon every state party, and that goes for everyone, so including irregular migrants. Likewise, at the European regional level, the revised European Social Charter contains a similar obligation. Here, the European Committee on Social Rights, which is the body that interprets the European Social Charter, has also held that the enjoyment of the minimum core of the rights set out in this charter that are essential to maintain human dignity must be ensured to foreign nationals within the territory of a state party, even if they're there illegally. So the GCM, what it does is it crystallizes these doctrines that have been developed by the quasi-judicial bodies of human rights instruments and underlines their relevance to migrants. So what we can conclude from this is that the GCM and international human rights law mutually strengthen each other. And reading them together, we can conclude that the EU and its member states are accountable for guaranteeing a minimum standard of socio-economic rights for all migrants in the EU or on their territory, irrespective of their status, in order to live up to their commitments under international law. Thank you. That's it for now. If you're interested in further reading, please look out for Human Rights Challenges to European Migration Policy, Chapter 6. The book will appear soon with Normas and Hart. I look forward to your questions.